What's going on, y'all? Attorney Tom here, back with Spammyware, where I'm attempting to make a video every single day for the month of January. Today is Sunday, January 21st, so that means there's only 10 more days left in January, and I'm kind of running out of ideas. So I asked you guys for recommendations to post on the subreddit, and that's exactly what I'm going to be reacting to today. r/PackJessBoots123 says, petition for Attorney Tom to react to the Dutch equivalent of the USCSB, which discusses safety incidents in the Netherlands. And remember to stick around to the end of the video where I am going to give my percentages of fault. Let's get started. Attorney Tom. I don't take sponsors. The only thing I ask is that if you need a lawyer, contact my team for a free consultation. While most people know me as a catastrophic personal injury lawyer, I'm actually a partner at 2 law firms that handle way more than just catastrophic injury. If you were the victim of securities fraud, received a notification that your info was included in a data breach, developed cancer as a result of a bad drug or toxic exposure, and many other situations, we may be able to help. It's important you talk to a lawyer right away to understand your options. If your case is not the best fit with us, we can help you find a great lawyer by using our national network of attorneys. Please click the link down below for a free consultation.
On the 23rd of January 2016, a passenger train collided with a man lift crossing a level crossing between Dalfsen and Ommen. When a train derails and ends up on its side, the effects are serious. In the investigation, the Dutch Safety Board therefore looked for answers to the following questions. What precisely happened? And what lessons can be learned from this accident?
Okay, and I know we're talking about the Netherlands here, but I'm an American catastrophic injury lawyer, so I'm going to apply analysis with the tidbits and information that I know, applying American catastrophic injury analysis, right? So what's interesting about the railways, because it's been around for a long time and it's such a vital part of the American infrastructure, there's actually tons of special laws that govern railway and railway-related incidents, and I'll probably try to apply them as this situation unfolds.
The accident occurred is the intersection of the railway connection Dalfsen-Ommen and the largely unpaved road Het Lage The man lift, rented to a landscaping firm, was delivered by the rental company by low loader. Because the low loader could not cross the level crossing, the man lift was unloaded at the start of the unpaved road. The man lift had a maximum velocity of 1 km per hour. The employees of the landscaping firm thought they had sufficient time to cross the level crossing after a passing train. They did not check the timetable, nor contact track manager ProRail.
Okay, the very first thing we need to do is identify the parties, because at least in America, the relationship between the negligent party and the injured parties can make or break a case. It really sets the stage of what legal remedies are available. So here, I think so far there are three parties that I've identified. We've identified the landscaping contracting company who is operating the machine, which they rented, which would be our second party, the company that rented this machine out, and then obviously the railway.
On the way up, the man lift passed the level crossing well before the next train arrived. After finishing their work, the employees of the landscaping firm assumed, supported in their belief by the successful crossing the previous day, they had at least 10 minutes to cross.
Okay, well, regardless of country, this is a very common reason as to why catastrophic injuries happen in the industrial workforce, and that is just because you do something once and it worked out doesn't mean it was safe. Here, the contractors just assumed that they had enough time. They didn't check any of the railway's timetables. They didn't call ahead and maybe schedule a specific procedure to either delay or slow down the trains or put the trains on notice that they would be crossing. They just did it, and probably because they did it successfully the day before, gave them a false sense of confidence. But, we're not out of the woods yet on identifying all of the negligence.
Just like the previous day, they waited for a train to pass. After a train to Dalfsen had passed, the operator of the man lift started the return journey. When the train arrived in Dalfsen, another train left the station in the opposite direction. During the crossing, the operator saw a train approaching from the direction of Dalfsen. At this point, the train was at such a distance that the level crossing had not yet been activated. The operator tried to warn the train driver by waving his arms. Realizing a collision could not be avoided, he jumped out of the man-lift.
Okay, another thing that I would want to know as the lawyer, regardless of who I was representing or who actually ends up getting hurt, is were there any other reasonable safety measures or warning systems that the train track could have implemented? Because for me, if I'm a railway operator, it's foreseeable that at some point in time, one of the railways will be clogged up with some obstruction. So now that it's foreseeable, how are we going to address it? What kind of warning systems? Is there any sort of warning system that we can attach on the crosswalk to the train to let them know that there might be an obstruction in the railway? Obviously, I know trains are incredibly heavy and you can't just stop them like that, but what kind of systems in place can we do to mitigate the foreseeable instance of an obstruction in the railroad?
The train driver gained sight of the level crossing at a distance of approximately 350 metres due to a curve in the railway line. Only at a distance of 175 metres he was able to see that the level crossing was not cleared. He almost immediately applied the emergency brake, which decelerated the train from 140 km per hour to 130 km per hour. The train driver had no time left before the accident to leave the cab. The impact of the collision demolished the cab of the train. An overhead lines pole was hit and the train derailed. The train driver was killed in the accident and 2 occupants sustained injuries.
Okay, so that's important. The train driver was killed and 2 occupants. Now, the 2 occupants are just going to be third parties. They are going to have the most amount of legal remedy available to them. They're going to sue everybody. They're going to sue the contracting company that was driving the machine that was obstructing the railway. They're going to sue the company that rented out the heavy machinery to a company that might not have been trained, negligent entrustment. They're going to sue the railway for not having adequate training or notification systems for allowing this to happen. Maybe it was a visibility thing, but that's maybe even a weaker argument because at the end of the day, I mean, the geography is the geography and you can't really, there's only so much you could do there. That doesn't necessarily offend me. But certainly there is probably some safety mechanism that they could have employed. Now, with respect to the train operator's case, that is much more legally interesting. And of course, I'm using American law and I'm going to ramble for a little bit, so bear with me, people. Of course, the train operator is going to have a third-party case against the landscaping company and the negligent entrustment claim against the heavy machinery rental company, right? But they probably also have a claim against their employer. After all, they were hurt in the line of duty. Now, most of the time, if you get hurt as an employee for a company, there's something called workers' compensation. And workers' compensation varies from state to state. Most of the time, it's incredibly predatory. It basically bars a fair recovery for employees who are hurt by the negligence of their employer. However, because trains have been around for such a long time and they're such a vital part of the American infrastructure and they have such strong unions, there actually is a law that allows injuries or railroad worker employees who get injured in the course and scope of working on the railroad to sue their employer. It's called the Federal Employers Liability Act, and I think it was passed in 1900 or 1903, and it's a great law. It's a great law. It actually allows an avenue for recovery for railroad workers specifically, and unfortunately, the truth of the matter is most catastrophic injuries that happen on a railway happen within that employee-employer relationship because there's just so many things that could happen. There's so many dangerous chemicals. It's not really a very safe place to work. So I'm glad they have that law. Which leads us to the next question. How could the train operator even make the claim that their employer was negligent when these wahoos put their excavator, whatever the hell it was, in the middle of the railway? Well, again, it's foreseeable that a railway or crossing gets obstructed from time to time. So I would argue that you would need adequate warning systems that the train has.
The investigation following the accident raised several lessons for improving level crossing safety. Crossing a level crossing with exceptional road vehicles is dangerous. The Dutch Safety Board recommends that it should be made clear to users of level crossings if they're able to cross without additional information from the Track Manager ProRail. In other countries, such as the United Kingdom, this is already a practice.
And I would go as far as to say a general good rule of thumb is if you have to ask whether or not you have an adequate amount of time, then you don't have an adequate amount of time. You should just call and inquire and ask for a delay if necessary.
The board also recommends ProRail to set up a procedure to allow users unable to cross without additional information to do so within a reasonable amount of time. Operators of exceptional vehicles should be more aware of the risks involving the crossing of level crossings with heavy road vehicles. These risks need to be pointed out during training and in rental contracts.
So this goes to the negligent entrustment case that I was talking about. If you have heavy equipment, you shouldn't be able just to rent it to anybody if they ask. Here was a landscaping company. Did this landscaping company have effective training of operating this man lift machine? And I would argue they didn't, because they put it in the middle of a railroad and it got destroyed and killed people.
Road users cannot raise alarm if they encounter problems on a level crossing, and trained drivers are not warned when a level crossing isn't cleared. The Dutch Safety Board recommends that such a system is installed, especially now the use of rail infrastructure is intensified. The severe effects of the accident were caused by the high speed of the train, the late visibility of the level crossing from the cab of the train, and by the manlift's large mass and rigidity. In the risk assessment of any level crossing, it's important to take into account the type of road traffic and the possible effects of occupants of the train. To improve the safety at level crossings, a closer cooperation between road managers and ProRail is required.
Okay, after hearing everything, I would put a third of the fault on the railway company for not having an adequate warning system. I feel like that is not very hard to install, especially with modern technology. I would put a third of the fault on the landscaping company that was in charge of the man lift, driving the man lift, not parking it, but having it on the railway. And I'd put a third of the fault on the company who negligently entrusted an untrained company to come and drive their heavy machinery. What do y'all think? What are your percentages of fault?
What is that?
Talk to you later.